Good morning. The court is now in session. So that means you all have to be extra quiet. We have 3 judges here. Good morning, everyone. My name is Ed Davis. I'm with the law firm of Astigaraga Davis here in Miami. I have the pleasure of and privilege of serving on the advisory board for OffshoreAlert, and we have the pleasure and the privilege of having 3 extraordinary justices here to assist us in understanding legal developments in the offshore world. I don't know what it says in your program about what the title of this is, but that's not what we're doing. So let me tell you what we're doing. We're doing legal developments in cross-border litigation and asset recovery. And we know that that appeals most broadly to this audience, and so we have the, as I said, extraordinary privilege to have 3 sitting judges here who are, think about that, who are willing to come in and share insights with regard to cases that they've handled or been involved in over since this time last year. And that's a very rare occurrence, and so let me, and we want to encourage them to keep doing this. So I'm going to ask you to do something different than we do in most cases when you applaud at the end. I'm going to ask you to applaud at the beginning and thank them for coming here. Let me introduce our panel. Our panel will start with Justice Neville Adderley, who is with the Court of Appeal of the Bahamas since 2012. Before that, he was a Supreme Court justice in the Bahamas at the trial level. He will take us through some general principles that have come out of some recent cases, and then take us through 2 specific cases from the Bahamas. After Justice Adderley, we will have Justice Edward Bannister. He's the commercial court judge of the Eastern Caribbean Supreme Court and sits in the BVI, and he will take us through 3 cases of import, and you will see a theme develop out of these cases that we've selected to talk about. And then lastly, Chief Justice Ian Kawaley of the Supreme Court of Bermuda. And I've had the pleasure to instruct counsel before all 3 of these courts, and we are lucky to have 3 of the most important jurisdictions in the offshore world to be represented here by their justices. And I'm going to have the luxury, which I normally, when you're a lawyer standing at the podium before court, you'd never, ever interrupt the judge. I've got permission to interrupt them today. And I'm going to ask them questions. Normally they're asking me questions. So this is a rare thing for me, so I'm going to enjoy every minute of it. But I'll be sparing Justice Adderley with regard to my interruption. So without any further ado, let me introduce again Justice Neville Adderley, and he'll take us through some developments in the Bahamas.
Thank you, Ed. I am honored to have been invited again to this well-organized and informative conference. This morning I will deal with cross-border asset recovery, and that is a complicated topic that really should be allocated about 3 to 4 hours. But have no fear. I say to you, like King Henry VIII said to his 5th wife, I won't keep you long. In fact, I won't keep you longer than the 25 minutes that they have allocated to me. Cross-border asset recovery normally takes place under one of 2 regimes. One, the criminal regime. But I should have a little
Clicker? Oh. Do we have somebody in the back? Oh, there we go. Pardon? Oh.
Was it? Oh.
Here it is. This thing.
Yeah.
I would imagine the big green button.
Oh.
That should do it.
Okay. Sorry about that. One, the criminal regime in which a foreign government is attempting on its own behalf or on behalf of victims of crime to recover assets determined to have been obtained from the proceeds of crime. And 2, the civil regime, either when private individuals wish to recover the fruits of their judgment in a foreign country, or where proceedings are instituted by regulators in one country to assist victims of fraud in their country to recover assets of wrongdoers located in other countries. Now, at the risk of oversimplification, I might nevertheless at the outset, try to briefly set out the bare bones of the general principles and processes so as to be more easily recognized when we discuss the cases. I recognize that for some of you, being senior practitioners, this might be treading on familiar ground, and so for that I apologize. Dealing first with the civil regime, this consists of two parts: statute and the common law. In the Bahamas, the statutory provisions are embodied in an act called the Reciprocal Enforcement of Judgments Act. No doubt there is a similar act in most of your countries as well. The act allows a person to register a judgment in a country with which their country has an agreement to do so. And there's a clearly laid out registration process. The limitation on the Reciprocal Enforcement of Judgments Act is that most countries, including the Bahamas, have a limited number of countries with which they have agreed the judgments can be reciprocally enforced. In the case of the Bahamas, for example, it is those few countries listed above, 10 of them, listed on the slide. Outside of those countries, which exclude, for example, the United States, there is no reciprocal arrangement. This then leaves the cross-border enforcement in those excluded countries to be undertaken in reliance on the common law principles. For the judgment to be recognized under common law, four things must apply. One, the foreign judgment must be final and conclusive on the merits. I have found, especially in the appellate level, that the issue of whether a judgment is final and conclusive is always fertile ground for argument by attorneys.
Mr. Justice Adderley, can I ask you, does final and conclusive mean that it's not on appeal in the jurisdiction in which the judgment was entered, or does it mean that it's final and conclusive at the trial level?
Well, there are always many arguments on what is final and conclusive. Depending on the circumstances, one of the tests is whether or not the judgment was on the merits, the person had an opportunity to be represented, and the person did not appeal from the judgment. That is one of the cases where it would be considered final and conclusive. There are other situations as well, and perhaps as we later on we can go into what some of those circumstances are. Does that answer your question?
Yes, it does.
Okay.
Thank you.
So it has to be final and conclusive on the merits. Two, the foreign judgment cannot be impeachable for fraud or breach of natural justice in the foreign country. For example, the defendant must have received notice of the hearings and must have been given an opportunity to be heard in accordance with natural justice. Three, the foreign country must have had jurisdiction over the person against whom the judgment was made, namely his having voluntarily submitted to the jurisdiction or being closely connected with it. And four, the judgment is not contrary to public policy. For example, the judgment is not to enforce a foreign tax law or penal law. The older legal authorities suggest that a foreign judgment could only be enforced at common law if it was a money judgment. But I think the better view now is, having regard to the later authorities, is that the judge has discretion to recognize non-money judgments as well. The process for cross-border asset recovery in the civil regime usually follows these 7 steps. 1, Mr. A commences proceedings against Mr. B in country X. 2, Mr. A then seeks information about Mr. B from banks in the Bahamas by applying to a court in the Bahamas for a so-called Norwich Pharmacal order with a view to starting an action against B in the Bahamas. 3, Mr. A may commence an action against Mr. B in the Bahamas. 4, Mr. A also immediately seeks orders to preserve Mr. B's assets in the Bahamas so that they would be available should his action be successful. This is the Moravian injunction or freezing order. If there is a serious risk of evidence disappearing, he may also seek an Anton Pillar order to search, seize, and preserve evidence. 4, Mr. A obtains judgment against Mr. B in country X. 6, Mr. A registers the judgment in the Bahamas under the Reciprocal Enforcement of Judgments Act or has it recognized under common law by suing on the judgment for summary judgment. After registration or recognition, Mr. A recovers Mr. B's assets under the local enforcement laws of the Bahamas. So that is the civil regime in a nutshell.
Can I make one comment on that? If you had heard this same speech 10 years ago, it would have only been the bottom point, obtain judgment. What you've seen now is if you're trying to recover assets by just waiting until you get a judgment and then doing the other work that Justice Adderley indicated with regard to Anton Pillar and Norwich Pharmacal, it's going to be rough sledding. So now you see the regime that's emerged over the past decade or so, maybe a little longer, where you have efforts to secure evidence and efforts to secure assets in anticipation of a judgment. That is a critical change in thinking that has happened through conferences like this where you have thought leaders.
Thank you very much. That's a good point. Now, the criminal regime is dominated by statute. Since 2000 through the coercion, if I may call it that, of the OECD and the FATF, a compendium of criminal cooperation legislation, which is replicated in over 160 countries around the world, have been developed, giving effect to various treaties on the matter. In the Bahamas, criminal cooperation statutes allow for recognition of judgments and forfeiture of assets of persons who have been found guilty of crimes in the requesting countries, and in the meantime, granting of a restraint order or freezing order over their assets from the time that proceedings are instituted against them in the foreign country. And in order to determine whether proceedings are instituted, what that means, there's a schedule attached to one of the acts which sets out the 160 or so countries and sets out what it means that proceedings have been instituted. And so when taking action, the applicant will have to convince the court that proceedings have been instituted. But that's fairly set out in the schedule to the act. The criminal regime has a parallel process to that of the civil regime, except it is commenced and progressed by the state, not individuals. The process involves the following 7 steps. 1, country X institute proceedings against Mr. B in country X. 2, country X may make a statutory request to the Bahamas to take action through the Attorney General of the Bahamas on its behalf to obtain further information about B's assets in the Bahamas. 3, through the Attorney General, country X obtains a restraint order in the Bahamas to preserve B's Bahamian assets that may be necessary to satisfy a future confiscation order against Mr. B. 4, Mr. B is convicted in country X. 5, a forfeiture order is made in country X against Mr. B's assets located in the Bahamas. 6, country X registers that forfeiture order as an external confiscation order in the Bahamas. And 7, country X recovers Mr. B's assets in the Bahamas. I will skip over cross-border asset recovery in liquidations and arbitration awards because each of these are governed by separate regimes which are contained in statutes which were passed in the Bahamas in 2012. Time will not permit me to go through those statutes in any detail.
Mr. Justice Adderley, can I just add one thing?
Yes, please.
In the United, just one nuance here is actually two. One is that in the United States and in some countries we have two flavors, if you will, of forfeiture. We have civil or non-conviction based, and we have criminal or conviction based, and they're very different. And your role as a victim or victim's counsel generally resorts to how do I describe begging? Begging is, I think, is what it's called, where you beg people to push your case. It's different in the civil law world, where in the civil law world you can actually bring a claim. We have many civil law lawyers here from Germany and other places. You can actually have a role in the forfeiture case as a litigant and actually get money out of the forfeiture case at the end and participate in the use of the evidence. So it is one subtlety. We don't have the benefit of a civil law judge here. I wish we did, to give us that other side of it, but I thought it might be worth mentioning.
Thank you very much. I think that's an important point, actually. And that completes the criminal regime. So with that brief review of principles and processes, I will now turn to the discussion of two recent cases in the Bahamas, which I think are relevant to the topic. One illustrates the elements of the criminal regime, and the other of the civil regime. The first recent ruling is that of Derek Turner against Edward Turner. There's no relationship between the two Turners. Derek Guys Turner, he was from Australia. Between 1999 and 2000, he persuaded Australians and New Zealanders to give him money to invest on their behalf. The Australian Securities Commission, after an investigation, commenced an action against him. A court found him guilty of trading without a license and prohibited him from continuing to trade. It also ordered that any loss caused to victims could be recovered from him, and the court later appointed a receiver of his companies. After his troubles in Australia, he relocated to the Bahamas. He adopted the same modus operandi there, and some people invested money with him on his claim that by using a special mathematical system, he could guarantee an annual return of 37% on his hedge fund to investors. He also attracted investors by representing that he had over $300 million on management in the Bank of Nova Scotia, Nassau. He operated by sending out accounting reports to support his claim of very high returns, which turned out to be false. As it turned out, he had $1.5 million in the Bank of Nova Scotia. From the Bahamas, he carried on his business not only with Bahamians, but also with Americans. In August of 2005, having been charged in the United States with mail fraud, wire fraud, and money laundering, Turner pleaded guilty to the offense of wire fraud and was sentenced to a term of imprisonment of 240 months, 20 years. In October of that year, the Attorney General of the Bahamas received a mutual legal assistance request from the United States Department of Justice to apply on its behalf for a restraint order prohibiting Turner from disposing of the Scotia bank account and his other identified properties in the Bahamas. On the 21st of December 2005, the Bahamian court granted the restraint order. Between May and December of 2005, however, the Bahamian victims had launched their own separate court actions against Mr. Turner. There were several Norwich Pharmacal orders, an Anton Pillow order to seize documents and computers from his office, the commencement of writ actions, orders for Moravian injunctions, and the placing of an equitable charge on his assets in the Bahamas. Mr. Turner did not file a defense to the writs, and so the victims entered default judgments against him in September and December of 2005, respectively. On the 15th of August in 2007, a Bahamian judge ordered that the properties be sold to satisfy the judgments. And the properties were in fact sold, and they yielded $8.2 million. In the meantime, in December 2005, Mr. Turner had appealed his sentence to the United States Court of Appeal for the Second Circuit of New York. He won the appeal, and on the 18th of December, he was resentenced de novo to a term of 87 months instead of 240 months. And a final order of forfeiture was then made, requiring Turner to pay restitution of US $55 million, and it imposed a US $6 million forfeiture money judgment against him, and ordered specific forfeiture of his Bahamian and Australian properties. The U.S. government, through the Attorney General of the Bahamas, then applied to the court to have the forfeiture order registered as an external confiscation order in the Bahamas. The United States wanted to recover the $8.2 million to add to the fund, which could be distributed ratably between all of the victims of his fraud. The trial judge in the Bahamas ruled that there were no more assets left to which a confiscation order could attach, and refused to register the United States forfeiture order. The United States appealed to the Court of Appeal, and having lost that appeal, abandoned further appeals and did not appeal to the Privy Council. So the Bahamian victims are in the process of sharing the $8.2 million after payment of expenses. But it did not end there. Having been released from prison, Mr. Turner returned to the Bahamas and mounted another action to try to have the court set aside the default judgments which had been entered against him in 2005. That series of actions was finally ended in the Court of Appeal last October, when the Court of Appeal ended his bid to do so. So that's the first case, which I say is based on the criminal regime.
Can I just ask a question?
Yes.
Usually forfeiture works against the race or the thing.
Yes.
Is the reason for the holding that the MLAT request, the forfeiture order, could not act against the money, is that the race had been distributed already and there was nothing for it to attach to?
Yes. By the time the forfeiture order was made, the race had already been distributed.
Oh, okay.
Because remember, the forfeiture order was made in 1989, but the assets were ordered disposed of since 1987. Sorry, 87 or 97? 97, to satisfy the judgments. So the judgments were first in time, and therefore it got priority over the forfeiture order. The second case illustrates the civil regime. This is the case of KPMG against J. Jeffrey Pocacher and others, as set out on the screen. The Ontario's the Ontario's Security Commission in 2006 brought an action for fraud against certain Canadian companies allegedly controlled by the defendants and their international business companies which were registered in the Bahamas. It was detected that one of the IBC companies had received a transfer of $3 million derived from the alleged fraud. The Ontario's Commission appointed KPMG as receivers of the companies, and it also ordered in the Ontario Securities Commission and the court also requested the cooperation of other jurisdiction in giving effect to the receiver's powers. The order also authorized the receiver to use whatever legal means that were available to take immediate possession of the defendant's properties. In October of 2009, KPMG applied to the Bahamian court for, among other things, a Norwich order aimed at First Caribbean International Bank, requesting certain account information on the defendants, and for an order recognizing its appointment as a receiver. The Bahamian court granted the orders. In February of 2010, a writ was filed by KPMG against Sequor and his companies in the Bahamas. The writ was not based on the judgment. It contained general claims of monies hadn't received, claims for account, damages for misappropriation, and the like. But the receiver was also granted possession of the luxury condo in which the defendants resided on Paradise Island in the Bahamas. All of the above orders, the Norwich Pharmacal order, the recognition order, and the order for possession, were made ex parte before a judge of the Supreme Court. The matter came before me as then first instance judge for an inter partes hearing whereby the defendants were seeking an order that the ex parte orders be set aside. Their main contentions were that none of the defendants were parties to the receivership action in Canada, that the orders of the Bahamian court had the effect of giving KPMG the fruits of a judgment which it did not yet have on the merits, and that there were material non-disclosures in the ex parte hearings. I accepted these arguments and I set aside the ex parte orders, including the order of possession. But I ordered that they should be allowed to return to their luxury condo and to be allowed reasonable living expenses and reasonable conduct money. The reasons for setting the ex parte orders aside, in keeping with the general principles which we discussed earlier, were: one, there was no final and conclusive judgment on the merits in Canada. Two, there was, of course, no judgment in the Bahamas. Three, the appointment of the receiver was, as it related to the condo, a judgment in rem, and the procedural rules of the Supreme Court of the Bahamas, which was the lex fori, for taking possession of real property, had not been complied with. And four, there had been material non-disclosures at the ex parte hearings. KPMG appealed to the Court of Appeal. The Court of Appeal allowed the appeal and set aside my judgment. From the record, it is apparent that after the hearing before me in November of 2011, in January of 2012, the defendants were in fact found guilty on the merits to have perpetrated a fraud on investors in Canada. They were found to have used funds raised on the sale of securities for their own personal purposes, to have been trading without being registered, and as directors to have allowed their companies to breach securities laws. The Canadian court ordered the defendants to disgorge $21.9 million to compensate about 600 victims. The defendants, although served with the proceedings, had not attended the trial and had not appealed the judgment, and so it became a final and conclusive judgment. All of this was revealed in additional evidence which the Court of Appeal had granted leave to KPMG to file in response to its application to do so. The receiver then set about tracing and recovering the assets from the victims of the fraud. The assets traced included money in First Caribbean International Bank in the name of 2 IBCs, 2 luxury watches, 2 Ferrari cars, a luxury condo unit in Paradise Island, Bahamas government registered stock, luxury clothing and furniture. Of the $21.9 million that had to be disgorged, assets valued at $7.1 million were traced to the Bahamas to be recovered. So those are the 2 relevant cases, and the principles generally accepted on which they were decided.
Thank you. I think one thing worth stressing for the American lawyers and the American practitioners here is that additional evidence was put in on appeal, which just doesn't happen in the United States. You don't see additional, it doesn't happen, it's impossible unless the court relinquishes jurisdiction and sends it back to the trial court. Without any further ado, then, we're going to go directly into Justice Bannister's 3 cases. And if you'll take us through your cases, Justice Bannister, I would very much appreciate it. I just learned that Justice Bannister is leaving the bench in March of next year, so it'll be a great loss to the BVI and to all of us who've watched the law develop out of the BVI in this area. So we will enjoy him as long as we can.
Well, thank you very much. That's a very generous thing to say. I'm not really going to talk about cases so much as some principles that have tended to crop up in cases of this kind, and perhaps invite members of the audience to make up their own minds as to what the right answers are. I'm certainly not going to suggest what the right answers are. Harking back to the question of enforcement in an offshore jurisdiction of a judgment of a foreign court, that might either be done, as Justice Adderley has said, under some enactment which provides for reciprocal enforcement. We have one in the BVI, but it's restricted to the United Kingdom. Or it might be done at common law. But taking the case of one done under our Reciprocal Enforcement Act with the United Kingdom, the stipulations or the requirements of the statute which must be met before the judgment can be enforced in the BVI are that it must be a money judgment, and the defendant must either have been present in the United Kingdom at the relevant time or have voluntarily appeared or otherwise submitted to the jurisdiction of the English court. We had a case quite recently where some of the complexities of modern civil litigation caused complexities in deciding whether somebody had voluntarily appeared or otherwise submitted. What had happened was fairly common. The defendants were neither present in England or had conducting business there, which I should have mentioned is one of the other requirements. But they had been validly served, and ultimately they all entered appearances saying both A, that they intended to contest jurisdiction, and B, that they intended to defend the action, which was obviously mutually inconsistent and gave rise to a certain amount of difficulty. But what really caused the problem was that, in common with many other pieces of litigation of similar size and appearance, the English High Court had made freezing orders against these 3 persons. And as is usual in that jurisdiction and in many other jurisdictions, the defendants were required to make affidavits giving disclosure of all their assets worldwide over some level or other, which was regarded as too trivial. Now, what those defendants did was to write immediately through London solicitors, challenging the jurisdiction, but saying, we will comply with the disclosure obligations in the freezing order. They first of all gave some voluntary information. When I say voluntarily, I mean they said, here's what we've got, and we'll give you an affidavit later. And then they decided that they would ask the English court's permission, still challenging jurisdiction, to suspend their disclosure obligation until after their challenge had been heard. because they said it was unfair, if we're not bound by this jurisdiction, that we should have to tell everybody who was interested what we own in wherever it was they held it. Well, the other side wouldn't wear that. So they went to the High Court in London and said, suspend our disclosure obligation until after our challenge application has been heard. And the High Court in London politely declined to do that. The day for the jurisdictional challenge ultimately arrived. The day before that day, the defendants sacked their lawyers. So the jurisdictional challenge went undefended. And the judge who heard it dismissed it. So the position was that they tried to challenge the jurisdiction. They had failed in that, but previously they'd actually handed the court the complete disclosure, which was duly handed to the claimants once the jurisdiction challenge failed. At that point, under English procedure, it would have been open to the claimants to sign judgment in default. But they didn't do that. They went to what they called a trial. In other words, they went and got a hearing date. They made their submissions. They called their witnesses. Nobody, of course, was there for the defendants. And they got a 56-page, I've just made that up, I don't know how long it was, written judgment for £11 million. They came to the BVI seeking to enforce that judgment under the Act. And because the defendants had not been present in England at the relevant time and weren't carrying on business there, the only question was whether on those facts they'd voluntarily appeared or otherwise submitted to the jurisdiction of the English court. The claimants were far too intelligent to suggest that the ambiguous filling in of the appearance form carried things anywhere. But what they said was, you can't possibly comply with orders, tell the other side you've got no intention of not complying, give them the information demanded, make applications to have various obligations postponed, and seriously argue that you haven't submitted to the jurisdiction of the court in front of which all this has been going on. And the question was whether what a voluntary appearance or submission means is doing things you're told to do, which they undoubtedly had, or whether there's something much more significant that is required, which is an express or implied agreement to have the particular dispute adjudicated upon by the foreign court. Well, I decided what the answer was, and you can, if you're that way inclined, make up your own mind about it. And I'm not going any further on that. The other case which raised a question which we possibly had adumbrated turns on this business of final judgments or finally disposed of. At common law and under most reciprocal enforcement statutes, it's necessary for the judgment sought to be enforced, the foreign judgment sought to be enforced in the enforcing jurisdiction, to have been final. And it is pretty well certain that that means that the particular proceedings which ended with that judgment should have no further life in them. And that's quite easy. The fact that there may be an appeal is irrelevant. Although, if the judge before which, or whom in most cases, enforcement is sought, is told that the foreign judgment is under appeal, he or she usually has a discretion to stay enforcement locally. But what about the words which occur in some rules of court? And sometimes elsewhere. What about the words finally disposed of? Shall not be enforced until the until the matter or the application, usually an application to set aside, shall not be enforced unless the application, or until the application to set aside, has been finally disposed of. What does that mean? Does that mean that, that an application to set aside, possibly in the court having supervisory jurisdiction over an arbitration, has been made? Or does it mean, or does it include, I should say, the case where such an application has been made but has failed and is the subject to a further or yet further appeal? What's the answer to that? Well, again, I know what the answer is, or at least I think I know what the answer is, but I'm leaving it to you to, if so inclined, make up your own minds. The third case I wanted to talk about is a different form of asset recovery. It's an insolvency case. And it arose, or arises, out of the collapse of a particular fund that, in this case, Blimis, the Madoff Fund. It has implications, obviously, for a lot of other funds which have become defunct since 2007. Many of the liquidators of companies which acted as feeders to these funds have been, and obviously Madoff's trustee himself, as everybody knows, have been anxious to try to claw back from paid redeemers who were paid out before the onset of liquidation either everything that they got or possibly what are described as excess profits or unlawful profits. How you work that out is not something which these remarks are concerned with. A particular clutch of feeder funds was incorporated in the BVI, and they're called Fairfield. And the liquidators of Fairfield sought to recover from paid out redeemers the amount paid out on the basis that they'd been paid by mistake. The mistake in question was that those who had the administration of the funds thought, as a result of the representations which were made by Madoff in this case, that they had much more money in the bank, so to speak, than they really had. And if they had known the truth, they would never have set net asset values at the level at which these people were paid. And they ran the case on two grounds. One, that the mistake was theirs and theirs alone. And two, that the mistake was a shared one. If won, then, if successful, the redeemers might have to pay back on the basis that the managers had been mistaken. If two, the redeemers might have to pay back on the basis that there was never a contract at all, because both sides had been mistaken and hadn't the first idea what it really was that they were contracting about. These cases, and I'll admit it, did come before me, and I decided that the case in mistake was hopeless, because you can't go to your travel agent after you've booked your honeymoon cruise and say, can I have my money back? Because I thought I had X in my bank account, but in fact, I didn't have anything. And the travel agent will normally refuse to refund on that basis. And I decided that that's what the liquidators were asking. But much more important, because it has a much wider significance, the Articles of Association of these particular funds had a provision that a certificate made on behalf of or by the directors as to the net asset value was binding on all parties. Now, if that worked, the liquidators could never recover, mistake or no mistake, unless, of course, there was unraveling type fraud, which no one was suggesting. I decided that contract notes or statements sent out by the fund's administrators as to the net asset value were not certificates. They were just statements. Certificate needed to be something more. The Court of Appeal agreed with me, but the Privy Council on April the 16th of this year did not. They said, and I'll tell you what they said. They said, as a matter of language, a certificate ordinarily means a statement in writing issued by an authoritative source, which is communicated by whatever method to a recipient or class of recipients intended to rely on it, and four, conveys information in a form or context which shows that it is intended to be definitive. And so that was complete end of case. Never mind mistake. All the parties were contractually bound to accept the net asset value which had been put out as binding, so recovery on any basis, however fanciful, was simply impossible. Now, so far as the law of the British Virgin Islands is concerned, that's it, because the Privy Council has spoken. But at the risk of being hanged or something for gross impertinence, I'm going to read you the definition again in a moment. Why are these words, no lifeguard on duty, not a certificate? And I'll read the definition again. It's a statement in writing. Well, that's no lifeguard on duty. It's issued by an authoritative source. That's the people who run the pool or the beach. Which is communicated by whatever method, scrawling it on a wall, to a recipient or class of recipients intended to rely on it, incompetent bathers, conveys information no lifeguard on duty. In a formal context, beach, swimming pool, which shows that it's intended to be definitive. And again, I leave it with you to decide whether no lifeguard on duty is, according to the English Privy Council, a certificate.
Thank you. Thank you, Justice Bannister. Let me take up your submissions in reverse order, because I just had a question on each one. I'm not going anywhere near the lifeguard pool or beach analogy. It's just too dangerous. I'm not a good swimmer anyway, as some of you know. My question is, does this mean that for those people who received these excess profits from the feeder fund, this particular feeder fund, that that's the end of the story and that those preferences or clawback actions are over and done? Or does it mean that just as to the issue of mistake, it's over and done?
It's the latter. It's a wide open question whether statutory clawback provisions are affected in any way by what the Privy Council has decided, and that is something I am certainly not going anywhere near.
On your second submission regarding the finality...
I didn't make any submissions.
Well, on your second lifeguard on duty submission, non-certificate, on the issue of finality, do you draw a distinction between an arbitral award and a money judgment, and why?
Well, I think that a money judgment, which is under appeal, and I think that's what you're indicating,
yes,
may give much more reason for hesitation on the part of the enforcing court than an arbitral award. And the reason, I don't think it's supported by authority. The reason is that a money judgment's, an appeal under a money judgment may be on the merits properly so called. In other words, a question of the truth of the witness or an allegation of forgery or something of that sort, which may go to the very heart of the debt which gave rise to the money judgment. Except in some primitive Neolithic jurisdictions, there are no appeals against arbitral awards at all. The arbitral tribunal deals with the merits. The only issue is going to be due process, really. And once the court can be pretty satisfied about due process, it doesn't have to worry about the underlying merits, because that's the nature of the arbitral process. So it's for that reason that I think, arguably, I don't think there's any authority on the point. A court might be much more ready to enforce an arbitral award, despite doubts it might have, than a money judgment.
Do you generally allow interim relief when a judgment is sought to be enforced, which is on appeal in the foreign jurisdiction?
I've never been asked to do that, and it might be that if it was a question of freezing assets, I would, and in fact I have done that. So if by interim relief you mean freezing orders, yes, certainly. But I've never been asked for any other kind of interim relief.
Thank you. And on the first fact pattern that you related, that is the fact pattern that drives asset recovery lawyers mad, because you have a defendant that sort of sticks their foot in the water and checks the temperature of the water. And then when they realize that it's pretty hot water, they pull their foot out and they squat down and they fire their lawyers and walk away. And then they say, take your default judgment and see if you can enforce it somewhere. And, you know, it seems to me that if you've come before the court, I guess we have to understand better what was the basis. You submitted that under that fact pattern that there was no business being done, which would be sort of a general jurisdiction. And there was no specific jurisdiction because they weren't tracing specific assets there, or there was no proprietary claim that was brought. But assuming that we do have some connection to the jurisdiction, does it really turn on whether the defendant submitted to the jurisdiction or whether the defendant is properly, or whether the court has jurisdiction over them? There's a difference between your actions and or whether you are generally there before the court. And I'm concerned we give too much power to the defendants to play tactical games.
Well, if they're present, that's their bad luck. They've got nowhere to go. I think all regimes of this kind are consistent on that. But you are, well, with respect, I should say, for the first time, I think I've said it yet. With respect, I think you're right that some of these rules are very defendant-friendly because it does give a pretty wide window of opportunity before a final decision needs to be taken about what they're going to do. I mean, these people obviously gave up at the end of the day. I mean, one doesn't know, let's be fair, the background to it. There may have been negotiations. I mean, goodness knows what was really going on in the documents, which, of course, I couldn't see. But, yeah.
Sure. Now, we'll ask Justice Kawaley to take us through 3 very interesting cases out of Bermuda.
Yes, good morning, everybody. The theme of my presentation is that if you are seeking to collect on any kind of obligation in Bermuda, that the legal system bears no resemblance to the Bermuda Triangle. Firstly, I'd like to thank Justice Adderley for giving an overview of the legal regime which exists in both civilly and criminally in the Bahamas. The Bermuda legal framework is broadly quite similar. Unfortunately, in the area of criminal investigations, and also government forfeiture, there haven't been any recent cases that have come before the courts, but it does happen on a regular basis that the Attorney General applies to the Supreme Court at the request of a foreign government to obtain an ex parte order seeking evidence about criminal investigations in various different countries. In late 2013, the Proceeds of Crime Act 1997 was amended to provide for civil forfeiture, again, on the application of the Attorney General. And under those provisions, monies that have been identified as being the international proceeds of crime which are held in Bermuda and which have been effectively frozen can now be actually forfeited, applying the civil standard of proof. So moving on to my cases, the first case I'd like to discuss is a July 2013 case which was called Fifth Street Corporation against Dobbin. The plaintiff in that case was a Delaware company that did business in New York, and the defendant was a Bermuda resident who had guaranteed the debts of companies that operated primarily in Canada but also in the United States. And the presenting problem in that case was that the defendant sought to argue that the guarantee was not in fact enforceable because the guarantee, which was governed by Ontario law, was unenforceable under Ontario law because the risks that the guarantor had assumed had been materially altered by the way in which the underlying secured assets had been disposed of in bankruptcy proceedings in Ontario, which had also been blessed by a corresponding order from the US bankruptcy court. Expert evidence was adduced as to Canadian law, and I was persuaded to find that, in fact, in part because the guarantor had actually been party to the bankruptcy proceedings in which the underlying secured assets had been disposed of, it wasn't possible for him to argue in Bermuda in defense to the enforcement proceedings that the assets had been improperly disposed of in proceedings abroad in which he had been participating and had notice of, and had not raised any objection. So that's an example of a case which wasn't appealed, of the tendency of defendants to seek to raise issues which they could and should have raised in another jurisdiction when they're actually being proceeded against in their own domicile under a document which most people would assume is a document that really doesn't provide much of a defense at all. The second case is somewhat more complex, and this is a decision of the Court of Appeal of Bermuda of the 10th of March of 2014, a case called Cada against Desarrollo. And the plaintiff, again, here had a guarantee and had obtained a judgment in Arizona, having commenced proceedings there in 2003. In 2013, following various jurisdictional challenges, final judgment on the merits was entered by the Court of Appeal, and the Supreme Court of Arizona refused leave to appeal. And so the Arizona judgment was sought to be enforced by the plaintiff, which was a Mexican company which did business, had a principal office in Hong Kong, and Desarrollo was suing Cada, which was a Bermuda company. And the case came before me, and the main issue was because this was a common law enforcement of a foreign judgment action, no reciprocal enforcement applies as between the US and Bermuda. The question was, has the defendant submitted voluntarily to the jurisdiction of the Arizona court? The company didn't have any sort of office in Arizona. It didn't have any other commercial links. And the question was what it did in the Arizona proceedings a voluntary submission? The position in Bermuda is that we don't have a statute that was enacted in England, the Civil Judgments and Jurisdictions Act of 1982, which appeared to me to limit the ability to hold that a voluntary submission has taken place, and to, in a sense, give the court a broader discretion to hold that there hasn't been a voluntary submission to foreign proceedings. And I sought to posit a pro-creditor theory that the Bermuda common law test for voluntary submission was broader than the English common law test. And the case went before I gave summary judgment. I should add that it's about 2 weeks after I gave summary judgment, the English High Court overturned the decision of a master who had also granted summary judgment on the same Arizona judgment and held that as a matter of English law, there hadn't been a voluntary submission in Arizona. The case went to the Court of Appeal. There, attention focused very carefully on the fact that under Arizona law, according to the opinion of former Chief Justice of Arizona, Zlackett, the submission had not been voluntary because Arizona procedural law required the defendant to actually defend the merits at the same time as the jurisdictional challenge. And the Court of Appeal agreed that it was arguable that if the opinion of Chief Justice Zlackett was accepted, that in fact there hadn't been a voluntary submission. The pivotal part of the decision, the leading judgment was given by Justice of Appeal Bell, was to apply the dictum of Justice Bannister in the Star Reefers pooling against JFC Group, in which Justice Bannister said this: I have come to the conclusion that I should not follow these decisions here. The reason is they have now become dead letters in the jurisdiction which they previously applied, and that for me to apply them here where they are not binding would be to introduce into the law in this jurisdiction an archaic rule which would throw English and BVI practice and procedure out of alignment. And Justice Bell then said this: it seems to me sensible the position in Bermuda should mirror that in England as well as that in other common law jurisdictions, and for my part I do not understand the rationale for applying any different test. So my pro-creditor, more flexible test on voluntary submission was incomprehensible. The reasoning for common law coherence and congruence of Justice Bannister was irresistible. The question that I think this case does throw up, though, is this: what should plaintiffs suing offshore companies be doing when they have a claim and when they know that the offshore defendant has a potential jurisdictional challenge? In this case, the litigation in Arizona lasted from almost 10 years before they got to a final judgment on the merits in Arizona. And nothing was done in Bermuda. And one wonders whether the plaintiff's attorneys might not have made more headway if they'd issued proceedings in both Arizona and Bermuda, and in some way forced the courts to decide which court was going to deal with it. And it does seem to me that typically when you have parallel litigation and a decision has to be made, a plaintiff has to elect where to sue, it's very difficult for a defendant to say, you can't sue me in Bermuda and you can't sue me in Arizona. You have to agree to be sued somewhere. And so I would encourage those acting for creditors of offshore companies to think that although you may not make as much fee income litigating abroad, you may at least be able to enjoy a trip to places like Bermuda, and you might be able to actually get a quicker judgment that you can actually enforce.
Can I ask a question on that, Justice Kawaley? Because the facts of this are really interesting. I don't know why a Mexican company chose to sue a Bermuda company in Arizona. There's nothing in the opinion that suggests why Arizona was picked that I saw. Is there anything you could shed on that?
Yes, I think there was an Arizona law. I think the contract was governed by Arizona law because there was some other related contract which had an Arizona connection.
Okay, assume that connection then, or we have that connection, but it shouldn't matter. The Bermuda company came to Arizona. It put forth a jurisdictional defense. It lost. It put forth a merits defense. It lost. It put forth a counterclaim. It lost. It then went up on appeal on all three of those points and lost. Then it went to the Arizona Supreme Court, and petition for appeal was rejected. So it did get to fully ventilate its jurisdictional issue. Now the English court and the Bermuda court are going to have to delve back into. I think you got it right, by the way, in your first instance.
Thank you very much.
Are going to have
it's
to
very comforting.
are going to have to delve into the issue of jurisdiction, which should be a layup, to use a basketball term, since we're in the playoffs now, with regard to the Bermuda company, because it's a Bermuda company. How are they going to challenge jurisdiction in Bermuda? I take your point that you should pick your jurisdictions carefully, but they did litigate all the way, and they did lose on appeal.
Well, I think the issue is what they're trying to do in Bermuda is not to actually have the trial all over again. They're trying to say, the plaintiffs are trying to say, we shouldn't have to try this matter all over again. We should just be entitled to get judgment based on the U.S. decision.
I see.
It really throws up the problems of not having reciprocal enforcement legislation or treaties, and it's one of the weaknesses of the international law in this area.
Yeah, it is. We have that structure with arbitration awards, but we don't have that structure on a multi-party basis with judgments.
Yeah.
So I'll let you take us to the third case then.
Yes, the third case, very quickly, is rather similar to the first case. It's another guarantee case, but it had a sort of winding up perspective, a case of a Grenco against Credit Suisse Bahamas Limited. And in this case, the Bermuda company applied for an injunction restraining the Bahamian company who it was admittedly liable to under a guarantee, from presenting a winding up petition based on the agreed debt. And the basis on which they challenged their right to be wound up was that they were, at least on a balance sheet basis, solvent, and also that there was a counterclaim that they were able to assert in Brazil against the conduct of the bank in the course of certain Brazilian insolvency proceedings that the underlying companies had been involved in. And they obtained, in support of this claim, it was again a claim that this a guarantee had been breached. The duty of good faith had been breached, and it was supported by opinion of very eminent New York counsel. And they came before me ex parte, and I felt it was a borderline case, but I did grant an injunction. And there then was subsequently an inter partes hearing before me when there was full-blooded argument on the question of what was the strength of this cross-claim. It was accepted that the claim under the debt was a separate claim that was not impeached by this, what was properly characterized as a cross-claim, because the guarantee in typical New York style had excluded any conceivable defense or set-off or anything in its boilerplate language. But nevertheless, it was asserted that the conduct of the bank in this bankruptcy proceeding, in pulling the plug on a restructuring plan, had been in breach of the duty of good faith. What was cited before me in that case, which was pivotal to my decision, that, in fact, the counterclaim or the cross-claim did not have sufficient substance to justify restraining the presentation of a winding-up petition, was a decision of the Eastern Caribbean Court of Appeal in a case called Angel Wise Limited against Stark Molly Limited, where the Eastern Caribbean Court of Appeal upheld the decision of Justice Bannister in a similar situation, applying this test that where the relevant cross-claim did not have sufficient prima facie plausibility to merit further investigation as to its truth, the court could properly ignore the cross-claim and in fact allow the pursuit of winding up proceedings in respect of the debt, which really in substance on its own merits was not disputed. And so in that case, I decided not to wait for the Court of Appeal to overturn my decision following the dictum of Justice Bannister. I decided to set aside my own ex parte order, and I discharged the injunction and allowed the creditor to present its winding up petition, or to pursue its winding up petition. And I should say, in reaching that decision, I was wholly concerned with the merits, and I wasn't at all contemplating what might happen to me if I dismissed a claim by a Bahamian company and ignored the wisdom of the angel-wise Justice Bannister and had to come and sit between a Bahamian Court of Appeal judge and Justice Bannister himself on this panel.
We are at our time limit, and we're back on track, and I would normally entertain questions from the audience at this point. Unfortunately, I have to be in bankruptcy court literally in 1 hour, downtown Miami, so I'm going to, but if there's one quick question maybe, anybody? No, my brother from another mother, Martin Kenny, has a question. I know he doesn't ask short questions, but I'm going to ask him to keep this question short, if possible.
Thank you, Ed. Justice Bannister and Ed had a little repartee going about jurisdiction, personal jurisdiction for purposes of receiving inbound judgments. Two principles, two thoughts. One, it's interesting to me that when judges under our English system or an Anglo-American system want to express sovereignty over foreign resident defendants, the rules of court and the rules of personal jurisdiction allow for fairly broad berth in giving leave to serve outside in the English language or using minimum contacts theory and long-arm jurisdictional statutes in America to do the same thing. And yet when we import the expressions of sovereignty as embodied in a foreign money judgment from abroad inbound, the traffic is not the same. There's no co-equilibrium. So we're more generous in grabbing holds of people abroad, but not so generous in receiving foreign judges' judgments. This is no one's fault here on the panel. This is just an observation about how the system creates confusion for parties and counsel and judges and is inefficient. Last point. Rubin and Eurofinance squashed an attempt, I think, by the Court of Appeal in England to create something called modified universalism, which said that if you have some connection with a forum like New York, and you're a director, an English director of a US-based company in bankruptcy, that a judgment made in default of your appearance there could be enforced under the principles of universalism as embodied in UNCITRAL cross-border insolvency cooperation notions. And the Supreme Court of the UK, though, rejected that and reverted back to old Dicenian territorialism in October of 2012. So, Ed, you were struggling, I think, in your repartee with Justice Bannister because you have the U.S. notion of connection, of minimum contacts, of conduct in the forum. If you are a Chinese seller of, let's say, lead-poisoned toys sold to American children, in theory, you're committing a tort in America.
That would never happen, Martin, I'm sure.
Sorry?
a Chinese company would never sell lead-poisoned toys to
Fair enough.
American
But
children.
my point is that that Moorgard Investments in Canada 25 years ago adopted is a departure in the British Commonwealth, and is now Canada is more closely aligned to America with something called the real and substantial connection test in terms of conduct, not just voluntary submission. So there are elements of the British Commonwealth that are moving closer to the American model, which I think accepts foreign judgments when there is connections by conduct to the forum as opposed to mere submission.
Maybe
Did you say the real and substantial connection test has been rejected?
In Canada, it's a part of our law under a case called Moorgard.
I'm sorry?
The Supreme Court of Canada 25 years ago adopted the real and substantial connection test.
No, I thought you were saying that has now been rejected by the Supreme Court of England.
Correct.
And Rubin.
Correct.
Okay.
So in England, we're reverting backwards to the 18th century. In Canada, we're trying to merge it up with the Americans.
But I think it was Justice Kawaley who actually, in your case, the Court of Appeal relied on Rubin to overturn your.
Yes,
ruling.
they did.
Yeah. And so I guess the issue there is we don't have a multi-party treaty with regard to the enforcement of judgments. And I went to a drafting session at the State Department once, maybe 6 years ago, where they're trying to draft a multi-party treaty, similar to what we have in the New York Convention and Panama Convention for arbitral awards. And it was a joke. It was absolutely a joke because the actual draft treaty had more blanks than words. There were literally blanks. It would be like the contracting party, blank, 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 and it would literally look like that because, and the reason is the United States government and maybe some others are terrified of agreeing to a statutory scheme where they will have to enforce judgments from what they consider what was the phrase you used, Justice Bannister? Neolithic, was it Neolithic jurisdictions? Yeah, and that's I think the concern. That's the driver. Whereas in the arbitration award, we don't have that concern because you have moneyed parties, essentially, if you will, that are very sophisticated, agreeing to be bound by the arbitral award. We don't have that in the judgment. So if an Iranian judgment finds Shell oil, or Shell's a bad example because it's Dutch, but an American company to be liable for, or let's say an Ecuadorian court finds, and that's a real life example, finds an American company to be liable for $25 billion, then the U.S. under the statutory scheme might have to enforce it. So that's the big worry, I think. And we do have some small pockets, like in Europe. We have the European Union where you can enforce judgments amongst the countries. We have the 10 countries that you indicated that are part of the Justice Adderley that have the reciprocal arrangement, all English common law countries from the English world, I think, right? But we don't have anything that's multilateral. So that's what we're struggling with, I guess. But any other questions, comments? Anybody want to respond to Martin? No? Well, then please join me again in thanking our panel.